G'day everybody. I'm going to walk you through the 2024 AGM agendas in this training session, and I will be explaining the changes. As you well know, the November end of year signal the change of the agendas for our forthcoming year. And obviously this training session, I'm going to be walking you through a number of things, beginning with the standard agenda, the additional motions depending on the scheme, and the new bylaws. So let's kick it off with the standard agenda. Now, there is a lot that doesn't change, which is the previous meeting minutes, the financial statements, the appointment of an auditor, etc. Also, the fire safety. There's 4 different motions, obviously dependent on the scheme. So if it's got an AFSS or it doesn't, or if it's a wind fire or it's a wind fire building that they're going to quote on, all that would depend on the scheme. Also, building warranties, the strata insurances, the capital works fund plans, those motions don't change. They remain the same as 2023. However, there is a slight change with the proposed budget motion. For 2024, we'll be removing the 5th insurance levy recommendation as a standard proposal and just sticking to the normal 4 quarterly levies. So the Philippines won't be putting in an additional insurance contribution. So just remember to make sure that your insurance is included in your administrative fund. Now, if you do want to propose the 5th levy, not a problem at all. You can just basically go to the 2023 AGM template and basically use the proposed budget motion from there, which has the wording in relation to the 5th levy. So that's optional for you guys. Arrears and payment plans remains the same, as does the Strata Committee election, restricted matters, Strata Hub, Strata Managers report, etc. However, the special bylaw recovery of costs for fire services and works by owners is brand new, as is the recovery of tenant-related costs. And I'll walk you through those in a second. And the management agreement appears, as well as the safety inspection reappears again. So listen up with this one. So the safety inspection will be mandatory for retail, commercial and industrial schemes, and for those residential schemes that Marco has indicated on his site inspection that he recommends they have a safety inspection. So for residential schemes that do not have a recommendation by Marco to do a safety inspection, you may remove the motion if you wish. However, it is obviously recommended that you keep it on and run that past the owner should they wish to get an inspection. But again, I'll leave that one up to you guys. Let me repeat it. Mandatory for commercial, retail, industrial schemes, and those recommended by Marco that should have a safety inspection that are resi schemes. All right, moving right along to the additional motions. So the additional motion is obviously dependent on the scheme, depends whether they apply. However, I'll start off with 2 that would apply basically for the first sort of 4 or 5 months of 2023 AGMs, and I'll explain why. So if you recall, the enforcement of bylaws and lot owners charges bylaws were our standard 2023 AGM motions, or AGM bylaws rather. Now, there was a change in about March or April. There's a couple of NCAT cases that were heard, and they basically said that if you had a bylaw that has the words, debt against the lot with reference to the recovery of costs, they are unenforceable. So if you recall, from about May or June end of years, we changed the bylaws, had them redrafted, had those clauses about recovery of costs redrafted to comply with the law. And obviously from then on, the new version of the bylaw or updated version of the bylaw has been proposed. Now, what do we do for the schemes that have the older version with the debt on the lot clause? Well, basically, we can repeal the bylaw and replace it with the new version, updated version that you'll find in the Favourites tab in Documents. So this motion has been updated to say this, that the Owners Corporation decide by special res pursuant to section 136 and 141 of the Act, and here's the difference, to repeal special bylaw enforcement of bylaws and replace with special bylaw enforcement of bylaws, in brackets, updated version, in the terms set out as attached to the notice of the meeting, see annexure, and that would be obviously your job as the manager to pop the annexure in, and to lodge notification of the bylaw and consolidated set of all existing bylaws for registration at New South Wales Land Registry Services. All right, so will we charge for it? Yes, we will. It's not our fault that the laws changed, and we're simply recommending an update to the previously passed bylaws. So with this, completely up to the strata managers, whether you want to put these 2 updated bylaws on, obviously take into account the bylaw that's been previously passed. So if it is the old version, obviously we should repeal and replace it. It's good housekeeping. And obviously, if it has the new version, then there's obviously no reason to put this option 1 and 2 on the slide here on the agenda. So hopefully that makes sense. So basically, let me recap. Optional for the strata managers to put this on. I would highly recommend that you do. Obviously, for the schemes that have adopted the old version of the bylaw, to basically have an enforceable bylaw should the thing go to NCAT. I understand, though, some of you may not want to, and the owners corporation might want to continue with the older bylaws, but bearing in mind they may be unenforceable. Again, not our fault the law changed. I know I've said that twice, but here's the third time. It's not our fault the law changed. All right, schedule maintenance. That motion is off the standard agenda. You can put it on if you like, if you find it useful for budgeting, etc. You can just pop the motion on, and the schedule maintenance calendar is in the reports tab under documents in Strata Space. Utility agreement, again, standard motion should you be proposing changes to utility agreements. And Strata committee training motion. Now, this will not be on the agenda for 2024 for the buildings who have passed it in 2023. So if schemes have not passed it in 2023, we will rerun the motion again, and this will appear on your agenda, so don't remove it. So basically, Kay will be checking to see if the item was passed, and if it was passed, she will not put it on the agenda. If it was not passed, we're going to give it a second run in 2024. Now, those owners, that have not previously passed it, they will obviously have the benefit of looking at the recordings from 2023, as well as any upcoming webinars. So that's your sales pitch for that. Tenant attendance at meetings, obviously up to you guys. Where that is required, pop it on the agenda. And the BMC and Community Association reps, Kay will pop those onto the required schemes. Moving on to our new bylaws. Now, there's a bit of a fire theme there. That's why I've got some extinguishers there in the background. Good on me. Okay, recovery costs, fire and works by owner bylaw. Basically, what this bylaw is basically to say, okay, if a lot owner has changed common property, i.e. put downlights in the ceiling, which is common property, and obviously under AS 1851 or changes in the law, that is non-compliant, that basically the lot owner bears the costs of repair and obviously any consultants, etc., etc. And basically any fines or whatnot, false alarm call-outs for any breaches that have occurred, it is basically recoverable against the lot. So the new version of the debt recovery or clauses have been put there in clause 4, but basically most of the detail there is in clause 2 and 3. So damaging common property and false alarms, have a read of this particular bylaw, but the high notes are basically that you shouldn't breach, you shouldn't breach the law. You shouldn't change common property without permission, and if you do, you obviously pay to get it rectified. Clause 2.3 talks around don't trigger a fire alarm, don't carry out works, to common property without consent, etc., etc. And obviously, they need sufficient evidence to satisfy, obviously, if they've had any changes that they've actually had approval, etc. So under clause 3, owners corporation's power in the event of a breach. Now, this is where the rubber hits the road. They're basically saying, okay, in clause 3.2, if the breach of clause 2.2 or 2.3.2, recover from the person responsible its costs of damaging flowing from that breach, including the cost of the works, obviously the cost of engaging engineers, cost of carrying out the work due to the type described in 2.2.3, Schedule B costs or add-ons, and any legal fees, etc. Now, if you have a look in clause 5, we've clarified that the law means the Act, regulations, code, standard, and including any Australian standard, including AS 1851. So what we're saying here is, due to AS 1851, obviously there's going to be a higher level of inspection, higher level of accountability, and therefore we will seek to recover costs should owners have gone ahead with repairs in their lots, and obviously we need to fix it. So that is that particular bylaw. So different to the fire admin cost bylaw, because that's more centric around the second and third inspection and recovering the admin fees. This is more around recovering the costs for doing works in a lot that obviously breached the law, or AS 1851, as it's clarified in clause 5.4. All right, next one, recovery of tenant-related costs. So again, an AS 1851 theme, and here we're saying that under section 258, obviously the law is the law. They're supposed to give us the name of the tenant, the address of service of notice of the tenant, date of commencement of the lease, etc., etc. But here we're adding an additional clause under 2.2 that they give us the phone number and the email address, and we're asking basically for that pursuant to this bylaw. And should we need to get into the unit, we're allowed to do so, obviously giving them 3 days notice, and if they breach that, then obviously they're up for recovery cost to send a fire inspector out or whatever the case may be. So again, the benefit to the owners corporation of this bylaw is basically ensuring that tenanted lots give us their contact details, and obviously under the banner of AS 1851, we're basically going to have to get into a roundabout, or not a roundabout, it is 100% of the lots. And if we can't get in, obviously we need the details of the person who lives there to be able to make further arrangements. And obviously the again, the recovery of costs section of the bylaw is compliant with the current legislation. So hopefully that makes sense. So 2 bylaws relating to AS 1851. The first one around repairs that have to be affected due to lot owners changing common property, and the second one around making sure that we get tenant details, making them accountable for that, and obviously recovering any costs associated with non-access or non-compliance with giving us the contact details, etc. So hopefully that makes sense. Any questions, come and see me. Have a good read of the bylaws before you pitch them, and we'll be sending around a script which obviously explains both bylaws as well, and I encourage you to have a read of that, and we'll go from there. Any questions, let me know. Hopefully that all makes sense. Thanks very much.